Hi, my name is Tracy Chauvin. I'm going to be walking you through tort law and tort liability for school personnel for EDL 850 school law. What is tort liability? It is a civil wrong for which a remedy may be obtained, usually in the form of damages. Tort claims usually involve state law and are based on the idea that individuals are liable for the consequences of their conduct. So let's talk a little bit about school personnel liability. The idea is staff are liable for the acts that may cause injury to a student while under the teacher's supervision. That could be physical or emotional. And there are two major categories, intentional and unintentional. An individual liability may occur when an action results in an injury. In this case, the plaintiff needs to demonstrate that the employee's action violated a clearly established law and the employee exhibited a reckless disregard for the rights of the plaintiff. Let's get a little bit into the cases. Golden v. Milford. This case involved an attack on a member of the boys' basketball team by several team members, but particularly one student who engaged in aggressive sexual behavior. The student aggressor targeted the freshman boy, while other members of the team held the student down while waiting to board a bus to travel to basketball practice. No adults were supervising the students. The coach was in his office, and he generally drove himself to practice, while the members of the team rode a bus. And the student aggressor put his penis on the young man's face while other team members held him down. During the course of the investigation, which the school did investigate, it was found that the student aggressor had a pattern of behavior throughout the course of his playing on the basketball team, and that it had been reported before that he'd done similar but not the same acts. The student victim and his parents filed suit against the student aggressor, the school district, and the basketball coach. They filed suit for negligence per se, civil hazing, sexual harassment, negligent supervision, intentional infliction of emotional distress, and vicarious liability. The acts that occurred were not acts of civil hazing and could rather be considered bordering bullying, so the school district was not held liable under the civil hazing statutes of the state. And there was also no evidence that the coach acted in a manner that would be considered reckless or willful and wanton that would lead to the liability and overcome the qualified immunity provided to government employees. So it was the basketball coach's duty to supervise the team, but there was no evidence that he did this intentionally or knew that this would occur. Barnett et al. V. Caldwell. This is the case of a high school student, Antoine Williams, who died after engaging in horseplay with another student while his teacher was out of the classroom. The attending teacher left her classroom unattended around 2:45 p.m. and asked another teacher to listen out for her class. Ms. Caldwell did not instruct the hall monitor to watch her class and returned about 15 to 20 minutes later. Antoine and another student were horsing around. Antoine fell to the ground with the other student on top of him. The incident caused Antoine to lacerate a major blood vessel by a dislocated collarbone. When the teacher came back into the classroom, Antoine was laying on the ground, and so she called for the nurse and then called for emergency assistance. The EMT took Antoine to the hospital where he was pronounced dead. After he was pronounced dead, the school principal called Caldwell and all the other school staff into his office to get the incidents of the details, did an investigation, but Caldwell lied, saying that she was in the classroom the entire time. She stopped the horseplay, but observed no activity that was out of the norm. She told the principal that Williams complained about his nose bleeding and fell to the ground when he tried to stand. A few days later, the principal learned that Caldwell was not in the classroom. So there was a subsequent outside investigation by an outside company. And Antoine's parents filed a complaint against Antoine's teacher at the time of the death. And so the court decided that the claim against the teacher in her individual capacity involved a discretionary act for which she was entitled to immunity. She found coverage for her class. That was corroborated with the teacher she asked, and she is allowed to go use the restroom, which is what she later admitted that she did. Cormier et al. Versus the City of Lynn et al. We have the case of a fourth grade boy who was pushed down the stairs by a peer, resulting in an injury to his spinal column and spinal cord, which resulted in the onset of quadriplegia. So the incident occurred while the students were lining up at the beginning of the school day. By late morning and throughout the afternoon, the fourth grade student complained to teachers and classmates of tingling and numbness in his extremities. His symptoms were not reported to the school nurse or any other medical professionals. By the end of the school day, he reported that his legs felt like dead weight and he needed assistance to walk out of the school. The student victim and his parents filed suit against the school district, alleging the district was negligent because staff had been informed about the bullying on multiple occasions but did nothing to stop it and did not enforce their own anti-bullying policies. They allege that he was subject to constant bullying at the school by a small group of students, including that classmate who then pushed him, which resulted in that onset of quadriplegia. The Massachusetts Tort Claims Act prevents school districts from being liable in a negligent tort claim action for any injury caused by a third party. So, the court explained that in order for the school district to be liable, the situation that created the injury must have been originally caused by the school district. So, the issue that was decided was not whether the school district was negligent for failing to act reasonably to prevent the bullying that led to his injuries. The complaint alleges that it was that we accept those allegations as true. Rather, the issue is whether under this act, the public defendants may be held liable for their negligence. No, they can't be held liable for that negligence because they weren't intending to do it and they weren't the ones that originally caused the harm. So what the court later said was those working at the elementary school could have and should have done more to protect the student, but under this specific statute, the school district, the employees, and the municipalities are immune from negligent tort claims. Andriozzi, the town of East Haven et al. So this case involves a 13-year-old track participant who ran into a bench that had been placed on lane 1 of the track. When he fell, he suffered a displaced fracture of the radius of his left wrist. So the student and his parents filed suit against a negligence claim against the and the cross-country coach for failure to provide a safe environment. They allege that athletic coaches are to provide assistance and safeguard for each specific participant. And that even if the court found the acts discretionary, the actions of the coach fell within imminent harm identifiable victim exception. Well, the court concluded that athletic coaches may use judgment and discretion to ensure a safe environment and to provide safeguards to students. They had the rest of the track to run on. Why was he running for practice in lane 1? And the plaintiff failed, so the family failed to prove ministerial duty exists. Alternately, the plaintiff maintained that the minor was an identifiable victim subject to imminent harm. Well, in this, the court explained that while students who are compelled to attend school qualify as identifiable class of foreseeable victims, that same does not apply to voluntary participants in after-school activities and off-school grounds. Because this was an after-school activity of track, there was no evidence that there would be an identifiable, foreseeable victim. So if this had happened potentially during the school day, during a PE class, they might have had a different outcome. PS versus Virginia Beach City Public Schools et al. Let's talk a little bit about this one. This is an interesting one. This case involved an 8th grade student who has a 504 for ADHD who became hyperactive during math class, asking questions, talking out, very fidgety. The teacher then grabbed the student's neck and wrote the word focus on the student's forehead. The teacher further instructed a peer to hit the student on his head every time he said something the teacher disapproved of. The student was struck 2 or 3 times by his peer per the teacher's directive. The student was also not allowed to wipe the word off of his forehead until he completed his work, and the teacher took a photo of it. When informed, the school conducted an investigation and the teacher was placed on unpaid administrative leave. He subsequently resigned. Parents reported this abuse to Child Protective Services. A criminal complaint was filed against the teacher who was found guilty of assault and battery and paid a $100 fine. Now the family has filed a civil suit, claiming that this teacher intentionally caused emotional distress when he wrote on his forehead during that math class. And so now he suffers from depression, anxiety, and post-traumatic stress disorder. This is currently in court right now, actually. So let's talk a little bit about some reflection. So some reactive measures that could be in place that would assist with this not happening. Following known policies and procedures and communicating them transparently, making sure that We constantly have protocols in place that teachers are following, that we're training on that we have professional development around these things, that we're doing some self-care moments so that teachers aren't getting frustrated, aren't getting stressed out. So putting those in place to make sure that these things don't happen. So for me, proactive and reactive are the same thing. But for a reaction, ensuring that we're constantly following all the policies and procedures of the school district and our laws. For the proactive, train staff, constantly evaluate and adapt policies and procedures based on the communication that we're getting, that the situations that are occurring, how can we constantly adapt to make sure that they don't happen again. And using tabletop exercises to review staff actions and modify procedures, especially during high intensity situations or when we have to use a behavior response plan. And ethics. We need to set forth a code of conduct that guides everyday behaviors and creates a culture within the community. Without these ethics being modeled and practiced, we can't base our culture off of anything. We fly by the seat of our pants. So in the social work field, we have broad principles that then guide our ethical choices. So service, social justice, dignity and worth of the person, importance of human relationships, integrity and competence. Those are all things that can also apply to educational leadership and our school community as well. Thank you for walking through these cases with me. I hope you enjoyed them.